WPM English Shorthand Dictation. Be ready for it. Start. Para. Hold that the registrar must necessarily convene a meeting of the general body of the society immediately upon the term of the erstwhile committee having come to an end of fresh elections having not been held. Full stop. This we so hold in light of the fact that there may be varied circumstances in which elections of office bearers of a society may not come to be held within the time specified under its rules. Full stop. It cannot be said that in all situations where elections of office bearers of the society have not been held, the same is attributable to a deliberate default on the part of the existing office bearers. Full stop. A stark example is the present cause and case itself, where on account of the appointment of the authorized controller as far back as in 1988, the elected office bearers stood removed and were unable to hold any elections whatsoever. Para. The dispute in this petition narrows down to the controversy as to whether the petitioner who has been found entitled to receive the information as per the order passed in second appeal on 7/11/2016 is to be provided on payment of additional fee or is to be provided free of cost. Full stop. The challenge raised is to the order dated 1/2/2017 with a prayer to quash the same. Full stop. The contention of the petitioner is that the public information officer who was obliged to provide the information erroneously rejected the application of the petitioner, and in spite of having succeeded in the second appeal on 7/11/2016, the information was not supplied within the period of 30 days as contemplated under section 7 in bracket 1 of the Right to Information Act 2005. Full stop. Even thereafter, that is upon the decision dated 7/11/2016, the situation remains the same. Full stop. The petitioner is entitled for supply the entire information free of cost after expiry of 30 days. Para. Replying to the said submissions, Shri Shankar Anand submits that keeping in view the nature of the provisions of section 3 in bracket 1 and 7 in bracket 6 of the Act, the said period of limitation in such a fact situation would be available to the petitioner in as much as the public information officer had rejected the application on 28/12/2015 itself, which was within the period of 30 days. Full stop. Consequently, if the information was not required to be tendered and the jurisdiction has been and had been exercised by the public information officer well within the time prescribed, then in that event the petitioner cannot claim receipt of information free of cost in the circumstances of the present case, where the second appeal was decided on 7/11/2016. Full stop. More so, where the petitioner himself had filed a recall application that came to be disposed of on 1/2/2017. Full stop. He therefore, submits that the claim of the petitioner being not tenable. Full stop. There is no infirmity in the impugned order, nor the petitioner can claim the information free of cost. Para. A perusal of the aforesaid provisions leaves no room for doubt that the information has to be provided within 30 days of the application. Full stop. The admitted position is that the application was rejected within the period of 30 days. Full stop. The petitioner thereafter filed a first appeal that was rejected on 4/2/2016 and then filed the second appeal, which was allowed on 7/11/2016 to the extent indicated stated therein full stop. However, while allowing the second appeal, the State Information Commissioner proceeded to direct that the information shall be tendered to the petitioner on payment of additional fee to be calculated as per rules full stop. It is this part of the order by which the petitioner is aggrieved after the recall was rejected full stop.